Thank you. Be seated, please. All right, we are here on two matters today: the Houston Livestock Show and Rodeo versus Hallmark, and Balboa versus Texas Children's. We will hear first in the Houston Livestock Show and Rodeo case, cause number 14-24-724-CV. Make your appearances, please.
Your Honor, Russell Post on behalf of the appellant.
Kenneth Fair on behalf of the appellee with my partner Hallmark.
And Mr. Post, rebuttal time reserved?
I'll reserve 5 minutes, Your Honor.
Very well. Proceed.
May it please the court. The principal question in this case, which involves a highly unique insurance policy, is whether the provisions that extend coverage when access to property is impaired can be harmonized with the general endorsements that exclude coverage for pollution and biological contamination. If they can be harmonized, then summary judgment must be reversed. And I want to focus on that central question in my time before the court today. Of course, the main approach to any interpretation question in our generation is textualism. And this appeal is at some level a litmus test of the court's commitment to textualism. Because if we're serious about textualism, it means adhering to the plain language of the document, even when the result is counterintuitive. This case, we all have to acknowledge, is unique. There's no other reported decision that deals with a policy that includes the language of this policy. And so there's no precedent.
Well, it's unique in a lot of ways in that it doesn't make sense when you're referring to provisions that aren't there.
That's exactly right, Your Honor. To a certain degree, there's an element of nonsensical nature to this case. And I anticipated that the insurer might take the position that the consequence of the plain language of this policy is nonsensical, but that's not the court's problem. That's the insurer's problem. Remember that the insurer is the drafter of this policy. The insurer is responsible for the plain language. And if the plain language leads to a result that the insurer says is nonsensical, that is the responsibility of the insurer, not the court. And so we can be honest and say the pieces of this policy don't fit together cleanly. Nevertheless, it's the court's responsibility to construe the unambiguous language as it exists. And on that unambiguous language, the civil authority and the ingress-egress extensions extend coverage to losses caused by COVID-19, and they are not subject to the general endorsements. Let me begin with what I think is the most important interpretive rule that the court will need to apply in this case, and it is, of course, the well-founded rule that policy provisions have to be harmonized. That's true of all provisions in insurance policy. It applies equally to endorsements. And endorsements must be harmonized with all other policy provisions, and in particular, because these endorsements are exclusions, they are to be strictly construed in favor of coverage. Any doubt is to be resolved in favor of coverage. Endorsements will supersede the language of the policy only if the conflict between the two is, as the courts put it, irreconcilable. The cases that the insurer cites, like the Mesa case, the cases that we cite, like the Starnet case, all agree on that. The question is whether those provisions are irreconcilable. And I think if I can take a step back for a moment, I want to provide a bit more context to that rule because I think it's central to this case. If you trace that rule about relationship between endorsements and the main policy back to its source, you find that the Supreme Court said in 1942 that endorsements will typically prevail over the main language of the policy because they're more specific. That decision was Drain versus Jefferson Standard Life Insurance. It's not cited in the brief. And so let me give you the citation. It's 161 Southwest 2nd, 1057 at page 1062. And the Supreme Court reiterated that more recently in a case called Jaw the Point versus Lexington Insurance, which is at 460 Southwest 3rd, 597 at 605 in footnote 7. That was in 2015. Why do I make this point? It's because here we have extensions of coverage that have to be construed in relationship to the endorsement. So it's not a conventional main insuring clause. The extensions by themselves go beyond the main coverage clause, and they provide the most specific provision for this situation. So when you look to the foundational rule that where there's conflict, you look to the most specific provision. We think here it is the extensions of coverage. And with that, let me turn to, yes, Your Honor.
You agree, I presume, that the all risk, you don't have coverage under all risk in light of the Lloyd's Baylor case, right?
I do not agree with that, Your Honor, because that depends on the proposition that that COVID would trigger the pollution exclusion. But the pollution exclusion is not subject to this extension of coverage. And that's the key provision here, because the extensions of coverage say that they apply except for losses, damages, or events excluded in Clause 6. And Clause 6 includes no material exclusion here. And the point
So is it your contention then that because the two extensions have an exclusion that doesn't make a lot of sense, that therefore the endorsement just simply doesn't apply?
Exactly, Your Honor. That's exactly right. The specific controls over the general. The extensions provide specific reference to one category of exclusions, and that is exclusions that appear in Clause 6. The general endorsements cannot be applied to those extensions without rendering the specific exclusions in the extensions meaningless and without rewriting those extensions, because
the extensions would still apply for something that's non-viral.
Your Honor, the extensions would apply only to the extent, in our view, the extensions apply only to the extent that they're not excluded by an exclusion in Clause 6. Clause 6E, for example, includes an exclusion of coverage for monitoring and remediation of pollution events. And so there's a specific provision in Clause 6E to a certain character of a pollution event. To read the general pollution exclusion to supersede that would render that provision surplusage, and it would require you to rewrite the policy, because the extension says it applies except as excluded in Clause 6. The insurer wants you to read it to say except as included in this policy. And that just rewrites the language of the policy. And as we point out in the briefs, if you look at...
Well, but why is that any different than the general provision? The general all risk provision says we provide coverage, and then you start carving it out.
That's right.
With various endorsements. How is that any different? Here you have an extension, albeit it does have a exclusion, it has an exclusion, but it has these extensions. Why wouldn't the pollution endorsement cover that?
Your Honor is exactly right to focus on the relationship between the main insuring clause and the extensions, because you're right, you have the main insuring clause that deals with cases of direct physical loss or damage, and then you have a series of exclusions that relate to that category of losses. But the extensions say explicitly the policy is extended to losses other than the main insuring clause, and then has its own self-contained set of exclusions. And so to read the general endorsements to apply to those extensions would be to nullify the specific reference to exclusions in the extensions. And I point out that if you look at paragraph 2A of the general extensions, that provision covers loss or damage insured herein. It doesn't use the language of the extensions we're talking about here. So that extension looks back to the general insuring clause and the rest of its endorsements.
Wait, give me that again. 2A.
2A.
The policy insures losses resulted from or caused by loss or damage insured herein.
Correct. And if you care to look at the bench exhibit I've provided, it's at tab C, and I think Justice Wilson, you have the copies there. Just to make it easy for the court, you can see in 2A, as the court has just recited, the policy insures loss resulting from or caused by loss or damage insured herein. And so that means that the loss has to be otherwise insured under the policy. But if you look then to the final page of this tab, where you see the two relevant extensions, interruption by civil or military authority and ingress egress, you see that that language is not used. The insured herein language is not used. It's a more specific provision of insurance subject to only limited exclusions. And that's what we ask the court to recognize, that these provisions can be harmonized. And the point here is that the court's obligation is to harmonize the provisions if possible. The court's obligation is to resolve doubts in favor of coverage, if possible. The insurer's obligation, in order to maintain this summary judgment, is to show that these provisions are irreconcilable. It cannot do so. We regard this as being the central question in the case. I think the question about direct physical loss or damage simply not applying under the plain language of these extensions is self-evident, so I haven't addressed it, but if the court has questions about that point, I'm happy to address those issues as well. And otherwise, I'll yield my time for rebuttal.
You'll yield your 15 seconds?
Yes, Your Honor.
Wishing I would get the extra 15 seconds. Good afternoon, and may it please the court. My name is Kenneth Fair. I represent National Fire and Marine Insurance. We believe this case should be relatively straightforward for this court to decide based upon the two cases involving Baylor College of Medicine that this court has just recently decided. I just want to back up a little bit on the question of how the court interprets insurance policies, because while I agree with our friends on the other side, I think there's some additional principles that need to be taken into account. Insurance policies are like any other contract, and so you interpret them in the way that you interpret other contracts. And one of those principles is that you look at the entire contract. You interpret the words of the policy based not just on particular bits and pieces here and there.
It's like any other contract, but in this case, you're the drafter, so ambiguities get construed against you, and we resolve ambiguities in favor of coverage as opposed to not, correct?
Correct, but that requires there to be an ambiguity. No one has actually asserted that there's an ambiguity in this case, and of course, even though there may be a different interpretation of the contract, that doesn't mean the contract is ambiguous. That's only a rule that comes into play in those circumstances when you have a true ambiguity that has to be resolved. I do want to point out that there are a couple of issues here in terms of the cases that my opponent cited. The StarTech case and the Jaw the Point case that he cited, in fact, both of those cases determined that the insurer won in those cases because the endorsements did in fact supersede the other policy language. And I think if it comes down to a question of which is more specific, I would have to say that the endorsements are going to be considered to be more specific in this case and in virtually every other case. And that is because it is limited, as I think you pointed out, to the specific exclusions of biological and chemical substances. And so, other risks that wouldn't be covered by that wouldn't be excluded by those endorsements, would continue to be covered by the policy.
Well, how do you answer Mr. Post's argument that because paragraphs 2B and C, the interruption by civil and military authority egress, that because they contain an exclusion, albeit to clause 6, that thereby we don't need or cannot get to the endorsements?
I think there are three responses to that. The first is I would disagree that the part referring to clause 6 refers to damage and a loss. I think that it's specifically talking about an event excluded in clause 6.
Well, I guess I'm just struggling to figure out what it is that's being excluded in clause 6.
Sure. So clause 6 is demolition and increased cost of construction. So the purpose of that clause is if, for instance, let's say NRG Arena caught fire, part of it burned down, and it became uninhabitable, and you had to knock the rest of it down. So that demolition and cost is covered.
Hang on a second.
Yeah.
Paragraph 2, the extensions of coverage. It's the whole extension of it, or the whole preface of it says this clause extends the coverage described in clauses 7B, C, D, E, F, G, H, and 7.1. What are those?
Yeah, okay, well.
There is no 7.1.
I understand that, Your Honor, there isn't. There was a drafting error that was that occurred because of the broker that used an old form of the policy, copied the numbering over, So I believe that those are supposed to refer to sections, number 1 in the declarations. But in any event, I
I'm
think.
sorry, so this is supposed to, it's supposed to cover, that 7 point B, C, D, E, F, and G, H is what? It should have been
I
what?
believe that's supposed to refer to 1, B, C, D, E, etc.
Okay.
In any event, I don't think it makes a difference in this particular situation because of the language itself. I mean, first of all, it says loss, damage, or an event not excluded in Clause 6.
What
So-
was Clause 6 intentional, or was that a drafting error?
No, Clause 6 refers to this section on demolition and increased
No,
cost of
I get
destruction.
that, but
Right.
was that intended,
Ye-
were these two extensions,
Yes.
B and C, was that intended to refer to?
Yes, because if you look at number 6, sub E in that says no liabilities assumed under this provision for increase of loss associated with enforcement of any law or ordinance, which requires the insured or others to test for, monitor, clean up, remove, contain, treat, detoxify, or neutralize, or in any way respond to or assess the effect of pollutants. And then if you look at the definition of pollutant, which is on CR 369, it's in 40R, pollutant is defined to be any solid, liquid, gaseous, et cetera, including but not limited to smoke, vapor, soot, fungi, bacteria, fungi, virus, mold, spores, vaccines, and waste. So, in fact, it's funny that they focus on that because, in fact, that very provision includes an exclusion that takes pollutants, including viruses such as COVID-19, out of coverage of both of those two extensions, the interruption and the ingress and egress extensions. So I think if you look at it from that standpoint, pollutants are excluded anyway. And then on top of that, you have this endorsement that says that essentially this policy does not cover loss or damage caused by contaminants or pollutants. And then it goes on to define a whole bunch of things, including again bacteria, fungi, and viruses. And so that is in fact the very language that in the XL Insurance case this court determined did exclude coverage. I will also point out we have 2 additional endorsements that are included here that exclude various things. One is the authority's exclusion that's contained in that pollution, contamination, and debris removal exclusion endorsement. It's number 5 on that, which says notwithstanding any of the provisions of this policy. That's very broad language. The company shall not be liable for loss, damage, costs, expenses, fines, or penalties incurred or sustained or imposed on the insured by order of any government agency. So again, we have that exclusion specifically in there as well. And we have the biological or chemical substances exclusion endorsement, which again modifies the policy and excludes pathogenic or poisonous biological or chemical substances, and of course COVID-19, the virus is pathogen.
Well, how do I reconcile endorsement BH4 paragraph 5 that you just referenced? That is, you're not liable for any damages at the order caused by at the order of any government agency. How do I reconcile that with the 2 extensions which seem to provide coverage for things that are caused by the civil authorities?
Well, I think the point there is, of course, what the Texas Supreme Court has said, which is that when there is a conflict between the 2, then the endorsement is going to control. And I think this is exactly the sort of circumstance where that's going to occur, where you have a provision.
But are we supposed to give meaning to every provision? And so on paragraph, in the extension B, you're providing coverage, but then under your interpretation, under endorsement DH4 paragraph 5, you're taking away coverage.
And that can happen. I mean, that's one of the purposes of endorsements for a policy. Endorsements are essentially a personalization of the policy for a specific insured. You know, these policy forms are generic. They're usually nationwide forms. They include a bunch of different terminology, some of which will apply, some of which won't. And then you have a bargaining process between the insured and the insurer, usually through a broker, in which different types of coverage are selected, and those are added or taken away by endorsement. Sometimes endorsements are added because there are changes in the law. Sometimes endorsements are added because they respond to the law in a specific state or a specific location. And so it's fully reasonable to take away coverage that was otherwise provided in the main policy.
Is there any procedure in place where there's a proofreader at the very end of taking pieces in and out that can go back and make sure it's clear and not disjointed?
I'm sure there is, and usually there is, but you know, I don't know the circumstances in terms of this particular situation, why there are these numbering issues. But that's, again, my understanding, and there's some testimony in the lower court that there were some mistakes that were made by the broker who was putting together the previous policy. I mean, this is a policy that has been renewed year after year. It's changed slightly from year to year, and apparently there were some problems with transferring from one to the other. That's my understanding of what happened.
It's not intentional.
No, that's correct.
How do you respond to Mr. Post's argument that extension A has the language insured herein, whereas extensions B and C do not?
I think that I'm not sure that that makes a difference, and the reason is because those particular extensions, if you look at them, they say this policy extended to insure loss sustained during a period of time. Okay, so there's a loss that's been sustained. When, as a result of loss, damage, or an event not excluded in Clause 6, I mean, I would argue that loss, damage, or an event not excluded in Clause 6 is going to have to be losses or damages that are covered by the policy. And so if you look back at declaration number 8, that declaration states what the policy covers: loss or damage insured. This policy insures against all risk of direct physical loss or damage to property. And so, you know, that definition, that understanding of what this policy covers, suffuses the entire policy. I don't think that you can pick and choose and say, well, you know, it applies here, but it doesn't apply there. You know, simply because they included that language in that particular section, I don't think that means that, well, then we have to say, oh, then it doesn't apply here. I think that you have to look at the entire policy. You have to look at what is it that's covered. And I'll give an example here. Let's take, for example, let's say there's a snowstorm or an ice storm in Houston, which happens now and then. And as a result of that, the police have to close down a lot of roads around the rodeo. And so, you know, people can't get there. Not as many people are able to come to the rodeo. Has there been a loss to the rodeo? Sure, of course. They don't have as many people there. They don't generate as many ticket sales, et cetera, et cetera. Is that a loss that's covered under the policy? No, because there's no physical loss or damage to the property itself. I mean, keep in mind, this is not a policy that's being issued to the rodeo.
I mean, that's
for
just
business
the
interruption.
Lloyd's case that we decided 6 months ago.
Exactly.
9 months ago.
Exactly, and that's why we think the Lloyd's case applies here. Is it's simply just a matter of this is not physical loss or damage. COVID-19 is something that you can, you know, squirt down some Clorox and wipe it up and it's gone. And so because there's no damage to the property, then losses that aren't covered by damage to the property, losses that extend from that or flow from that, the losses that are covered have to come from that. They have to come from something happening to the property, and that didn't happen here in the case of COVID-19. That's all that I have. Unless there are any further questions, I'll yield back 58 seconds.
Thank you. Rebuttal.
I'd like to make 4 points, and I'll begin with the final subject of discussion. And I want to correct, Justice Wilson, my answer to your question. When you asked me about the Lloyd's case, because I was thinking about the endorsements, I was thinking about the most recent decision regarding the endorsements. But with respect to Lloyd's Syndicate, the decision that applied the rule about direct physical loss or damage, as I've explained, that rule simply doesn't apply here. It is the rule under the main insuring clause, but the extensions do not use the language direct physical loss or damage. And that makes sense, because if you think about it, these extensions are about providing recovery for impaired access to the property. There will never be physical loss or damage with respect to that kind of insured event. And so that's why they're extensions of coverage, and that's why Lloyd is inapplicable here. The second point I'd like to make is that there's no disagreement about the controlling legal rule. I told you at the outset, your responsibility is to harmonize all the provisions, and that unless there is an irreconcilable conflict between the extensions of coverage and the endorsements, you must rule in favor of coverage. Counsel doesn't dispute that rule correctly. It is the orthodox statement of the law, and therefore he has to demonstrate an irreconcilable conflict. And on that point, Justice McLaughlin, I want to pick up on your question about the drafting process and just call your attention to page 672 of the record, which is included in the bench exhibits I provided. That provides the footnote at the beginning of the policy that makes explicit the insurer is deemed to be the drafter. And so to the extent that the drafting process failed here, that failure falls on the insurer. The risk of uncertainty falls on the insurer, not the insured. My third point then is, how do we approach harmonizing these provisions? And I think that counsel essentially concedes my point when he seeks to argue that the specific exclusion in clause 6E, which he acknowledges was deliberate here, which refers to certain types of pollution testing and remediation, would be an applicable exclusion here. Of course, that's not the case. When you look at the language of 6E, it's talking about excluding coverage for testing and monitoring and remediation. That's not what our claim is about. But he concedes that there's a specific pollution-related exclusion in 6E. That's my point. The extensions of coverage provide specific exclusions which cannot be reconciled with the effort to trump them by looking to the general endorsements. And therefore, you simply don't have any reason to regard these as being irreconcilable. The correct rule of interpretation is to harmonize them by recognizing that the extensions of coverage provide the exclusions that apply. They are only the exclusions in clause 6, which everyone concedes do not displace this claim, and that means coverage applies. And that brings me to my fourth point, and this is an unusual acknowledgement for counsel to make. I think the rule in this case would be a rule for one day and train only. Ordinarily, that is a dangerous position for an advocate to take. Ordinarily, courts are justifiably skeptical of that kind of rule. But it's not because of my advocacy. It's because of their drafting. They wrote this policy in such a way that the extensions are not subject to the endorsements. They could have written it in a way that made the extensions subject to the endorsements. As we've demonstrated, other provisions of the extensions are subject to the endorsements. Other policies with respect to these extensions use language that make them subject to these endorsements. It is the insurer's responsibility for drafting the policy. It is the insurer's responsibility for creating a policy that creates coverage that is not excluded by these endorsements, and it's the insurer's responsibility to provide the coverage that applies under the plain language of the policy. Unless the court has further questions, I will now yield a full minute of my time.
Thank you.
I thank the court.
All right, Houston Livestock Show and Rodeo versus Hallmark is submitted. You are excused, and we will take a minute or so and let you guys set up for Balboa versus Texas Children's Hospital. Thank you. All right, we're here on Balboa versus Texas Children's Hospital, cause number 1424659CV. State your appearances, please.
Good afternoon, Your Honor. Jerry Woodfield with the appellant, Ms. Balboa. Good afternoon, Your Honor. Again, that and Michelle Matthews for Texas Children's Hospital.
All right, reserving time for rebuttal.
10 and 5, if that's okay, Your Honor.
Very well. Please proceed.
Thank you, Your Honor. Good afternoon. May it please the court. This particular case involves the appellee in this case asking this court to adopt a standard with respect to religious exemptions and the sincerity of one's religious beliefs that is inconsistent with long-established case law from the Fifth Circuit Court of Appeals. What they did in their amended motion for summary judgment is rely upon district court cases in Wisconsin and Massachusetts, in Illinois and Oregon, all other parts of the country that have since been overturned. And so let me briefly just walk you through the history of the case and the exemption itself, because I think it's important to appreciate what Mrs. Balboa articulated in her request for a religious exemption from Texas Children's Hospital. So if you look at the exemption itself, Your Honor, you will see a whole lot of words that I would characterize as religious. And I'll show you how they link up to her underlying beliefs in just a second. So for instance, she begins talking about aborted human fetal tissue. She refers to the word beliefs, Bible, Scripture. She refers to Jesus Christ on 2 separate occasions. She refers to the Word of God, child of God, Creator, meaning God, religious freedoms, biblical convictions, believer, him, referring to God, sinning, religious exemptions, God's Spirit, God's temple, perfecting holiness, reverence for God. And then she actually cites 2 scriptures. She cites 1 Corinthians 3:16 through 17, followed by 2 Corinthians 7 verses 1, and where she links that up to putting contaminants in her body, including aborted human fetal tissues, which were part of creating the vaccine, that goes against her sincerely held religious beliefs. So we think it's very clear when she articulated her position that these beliefs were not only sincere, but they were consistent with Scripture. And then that's why she gave the judge, and in this case Texas Children's Hospital, scriptures that she actually cited. Well, Texas Children's denied the request. They concluded that her beliefs were not sincere. They ultimately took the position that what they call the body is the temple of the Lord defense is not applicable in the state of Texas. Interestingly, Texas Children's never actually followed up. This request was submitted online. There was no questioning, okay, well, you said the body is the temple of the Lord. You've talked about aborted embryos. You've talked about the Bible created sinning. They never said, what did you mean? So if they had concerns or questions about her sincerely held religious beliefs, you would think that they would ask her about those concerns or questions before terminating her. So we've laid out in our brief the policies itself that they put in place, but I think you'll see in both briefs, both sides have consistently relied upon federal case law interpreting Title VII. The Texas Supreme Court has made it very clear that the Texas Commission on Human Rights Act was modeled after Title VII, and thus when interpreting the Texas Commission on Human Rights Act with respect to religious freedom and religious liberties, you can use federal case law. And I think the ultimate case that's instructive for this court is Davis versus Fort Bend County. Now in Davis versus Fort Bend County, which is a Fifth Circuit case, unlike the cases that were cited in the amended motion for summary judgment that the trial court ruled upon, in that particular case, the court said when you're looking at religious exemptions, you look at them with shyness or a light touch. And that makes sense, because we don't want to put someone's religious faith on trial. We don't want to effectively implement heresy courts in the state of Texas. The court in Davis also said that this is a fact question, for the jury. But here, the trial court decided that it wasn't a fact question, that it was appropriate for the court to actually grant the motion for summary judgment. And I think what was persuasive to the trial court was some of the cases that were supported by Texas Children's Hospital in their amended motion for summary judgment. Let's talk about those. One of the cases that they cited was a case called Pasquarelli versus Asperillus. Pasquarelli, ultimately, they cited, and I think this is important to appreciate, a Wisconsin trial court decision at the time. A trial court decision. And in that particular case, they ultimately concluded that the body is the temple of the Lord, a defense is how they phrased it. In that case, the plaintiff was more concerned about her health and not as concerned about her sincerely held religious beliefs. So they
Well, is
made
it your
this.
position that so long as a employee uses terms as you've described, that's always by definition creates a fact question and you can never have summary judgment?
Well, Your Honor, I would say if you go and look at Davis, David makes it very clear that if you're using terms that would even suggest a sincerely held religious beliefs, that courts should approach it with shyness and judicial hesitancy.
Well, Mr. Patton just referred us to the Sixth Circuit case of Weiss, which held quite to the contrary.
Well, Weiss is very different in this particular case. If you look at Weiss, the plaintiff in that particular case, because that dealt with undue hardship primarily, in Weiss, the plaintiff actually requested an exemption from the COVID shot or COVID vaccine. That was granted. But the second part of Weiss dealt with an exemption from testing. So she had requested an exemption from taking the shot, but she had also requested an exemption from testing, a religious exemption from testing, which was denied. So this is not like Weiss. If this were like Weiss, then the exemption with respect to taking the shot would have been granted. It wasn't granted here, it was denied. Mrs. Balboa was perfectly willing to be tested. She was perfectly willing to wear a mask. She was perfectly willing to engage in any of the alternatives to the COVID shot. In fact, it's very clear that Texas Children's Hospital received 480 requests for religious exemptions. 387 of those were granted. 80% of all religious exemptions were granted. So yes, in their most recent letter to the court, they did come up with a May opinion in Weiss versus Texas Children's Hospital of Akron. But that case supports our position, Judge, because unlike Weiss, in this case, the appellant, Ms. Balboa, was not given the option to submit to testing. And in that case, again, the two big issues were not taking the shot and testing. And because she was wasn't willing to take the shot or willing to do the testing, then they felt like there was an undue hardship and she could not be accommodated. That's not the case here. And if you go back and you look at the cases they actually cited, if you look at the case of Passarelli versus Mayo Clinic, which they relied heavily upon in their brief, citing it, I believe, at least 8 to 10 times in different footnotes throughout the case, footnote 70, 73, 76, 77, 80, and 95, at least 6 times they cited that particular case. That court, that higher court, the Seventh Circuit Court of Appeals, after we had the oral argument on summary judgment, the Seventh Circuit reversed that case. The Seventh Circuit reversed that case and made it very clear. Let me read you some of the language because I think it's so important. So if you're going to ask this court and ultimately the Fifth Circuit to adopt a completely different standard, one I think is opposite to Davis versus Fort Bend County, that you should at least rely upon the opinion and the law as it then now sits in that circuit. And in the Seventh Circuit, the law now is such that, and I'll read to you what the court said. The court said that it should not undertake to dissect religious beliefs because they are not articulated with the clarity and precision that a more sophisticated person might employ, nor should courts require employees to choose between the binary alternatives of a religious reason and a non-religious reason to explain their perspective. So they're saying you don't have to have this precision where it's all safety or all religion. Clearly the two are inextricably intertwined in many occasions, and that was the case here.
What
People-
about,
Yeah, sure.
and I don't mean to interrupt, but losing time, if we feel there is a fact issue regarding the belief, what about the undue hardship?
Sure. Well, with respect to the undue hardship, I will go back to Weiss. In the Weiss case, which they brought to the court's attention recently, there were alternatives that were proposed. Take the shot, or you could be tested. Another alternative would be masking. You had a whole host of things that individuals were doing pre-shot, pre-COVID vaccine that were employed. Here, no alternatives were offered to Ms. Balboa. In fact, I think what's also compelling for the court to note is that, again, 480 people requested exemptions. 387 were denied. The interactive process did not occur. There was no conversation between Ms. Balboa and administration about her religious beliefs and about positions she could or couldn't hold moving forward. And finally, Your Honor, in my last 19 seconds, they also cited a case called Ringhoffer out of the 8th Circuit, and that was presented to the trial judge. Again, that case was overturned by the 8th Circuit, relying on similar logic that we found in Passarella.
Thank you. Mr. Patton?
Good afternoon, Justices. May it please the Court. There are 3 different paths that the District Court could have taken to grant the summary judgment in this case. The first one was the appellant's exemption request could not be accommodated by Texas Children's without undue hardship. A second reason the judge could have found summary judgment was that the appellant did not have a religious belief that conflicted with Texas Children's COVID-19 policy. And then finally, the third reason that the judge could have found summary judgment is if the court believed that the appellant did not have a sincerely held religious belief. For purposes of this afternoon, I would like to start with the undue hardship defense, as Justice McLaughlin brought up. And that's the easiest one to go by, because you can assume, I'm not saying for purposes, but if you believe that they've fulfilled the prima facie case, that they have identified a sincerely held religious belief that conflicted with the COVID-19 vaccine, they still have to overcome the burden shifts to us, the employer. And then we have to demonstrate that there was not a reasonable accommodation to the employee without an undue hardship. And what's interesting is that the motion for summary judgment stage of this case, appellant did not provide any argument or evidence to controvert Texas Children's undue hardship defense.
Was she given accommodations?
No.
Any offer?
She was not, Your Honor. She was not given any accommodations. They have rendered that the accommodation would be an undue hardship because of the patient population that they have at their hospital. We're talking about children, NICU babies, we're talking about cancer patients, we're talking about people who have children who have compromised immune systems, Your Honor.
Then why were other people given?
Well, Your Honor, that's not in the record as to why other reasons why they were given. It could be various reasons. It could be people that maybe didn't have direct patient care. It could be people that may be working remotely from home. But that is nowhere in the record as to why some people got and some people didn't.
Are
Your
these
Honor.
fact questions?
No, not to the analysis of an undue hardship, Your Honor. If you just look at the Wise case, you look at, I cited Wise for the opinion of, Your Honor, in it states, hospitals facing the pressures of the pandemic face immense pressure to keep their patients safe. And where hospitals present evidence that accommodating an employee's exemption would threaten the hospital's most vulnerable patient, such exemptions constitute undue hardship. Look at the Kaiser case, St. Jude's Hospital, Children's Research. Same exact thing. They came to the same conclusion. In that case, they said, specifically, the hospital establishes undue hardship by presenting evidence that to allow an unvaccinated individual to work on campus would pose a safety risk to the hospital's vulnerable juvenile patients who were largely immunocompromised and unable to be vaccinated. And then recently I cited to you guys the McDonald case out in Oregon. This is the United States District Court in Oregon. It is directly on point.
Why are you not responding to any of the Fifth Circuit cases?
Because there are no Fifth Circuit cases talking specifically about the undue hardship defense in regards to the COVID vaccination, religious exemption, in regards to a children's hospital. There are no cases in the Fifth Circuit yet. I'm aware of a flu vaccine that came out, and then we had a recently one from a Texas Children's case with Barry that's cited in our brief, and that was more of a free will case, not a body as your temple. But Your Honor, there is not a case that talks about the undue hardship defense with regards to a hospital, because if you go by the standard by the United States Supreme Court with regards to an undue hardship analysis, it's a common sense approach. We're talking about a children's hospital in the middle of a pandemic. And it says that the analysis of an undue hardship requires examination of both economic and non-economic factors or costs to the employer's business based on the information available to them at that time. And the economic costs that they're referring to is the safety and health risks. They talk about risks of reputational injury, and they also talk about legal liability are all relevant to your inquiry. In this case, Your Honor, Justices, we are talking about a registered nurse who worked in the labor and delivery department and had direct patient care to birthing mothers and to newborn babies, and she worked with other healthcare workers. They had concluded that there was too much of a risk to allow her to, that could not overcome the created safety health situation with these very vulnerable patients. Now, you may ask, oh, well, they granted.
Wasn't that the case in the Ballard decision out of the Southern District?
In the Ballard decision?
Yes, sir.
I'm not familiar with that one, Your Honor.
Well, it just came down, that was a year ago.
But what I'm saying, so you may ask about whether or not 387 got granted. Well, courts have said, and it's kind of touched on in the Wise case, it talks about, listen, if you suddenly grant this exemption, and let's say it's a free will exemption, and now let's say 22 others did the free will exemption, you are now putting 22 new unvaccinated people into this vulnerable patient population. And it says you don't have to consider that. Because like I said, there's nothing in the record as to why the 387 were granted. It's only the fact that there were 387 granted. So I asked you to look at the McDonald case out of the District of Oregon. We're talking about the three cases that I cited you with regards to Wise, Kaiser, and McDonald. Their cases are almost identical to this. We are talking about children's hospital cases, vulnerable patient population, and all three courts said the same thing. That was enough for an undue hardship. It's just a demonstration of the safety and health risk. In this case, I've given you more. We've given you evidence with regards to the reputational injury that could happen to Texas Children's if it starts letting unvaccinated workers working with patients and then patients get sick. It has a toll. It could have a toll on the reputational injury. And then legal liability. Having an unvaccinated worker get a vulnerable, sick child with cancer, COVID, gets them to legal liability. The courts have said take all these non-economic costs into consideration. And so that's why I say, even if he's right on she has a bona fide religious belief that conflicts with the COVID-19, he can't get past the undue hardship defense. Because the burden shifts back to me, and I've demonstrated to the evidence what cannot be controverted by him because they presented no argument or evidence at the lower court level during the summary judgment. So I'd like, if I could, Your Honors, I would go now to the second reason as to why the judge could find, because one of the elements they have to show is that they had a bona fide religious belief that conflicted with the COVID-19 vaccine. And a bona fide religious belief has to be sincerely held and religious in nature. And I would like to talk about the second aspect, religious in nature. And it is a very good question because you say, well, isn't this just a fact issue? It could be. However, when the evidence is so overwhelming to demonstrate that no reasonable juror could side that way, a judge has the ability to render that. Because if we just said that anyone who puts anything in an exemption request, that they get by summary judgment, then people can just do whatever they want. There was a case out of the Supreme Court, I didn't cite this, but this is the Wisconsin versus Yoder, 406 U.S. 205, 1972. It says, the delicate nature of this inquiry notwithstanding, courts have long recognized that some type of judicial review is appropriate, as it would offend the very conduct of ordered liberty for every person to make his own standards on matters of conduct in which society as a whole has important interests. So while a lot of cases do talk that this has potentially been a fact issue, and a lot of those were Rule 12B motions in federal court where they said for the pleading standard that there was enough, the evidence in this case is overwhelming. And let me go over some of the evidence. So appellant's exemption request fails to explain how her religious belief conflicted with the policy. The appellant testified that her opposition to the COVID-19 vaccine was tied to her view that she cannot receive the vaccine because Scripture says contaminated or unknown substances should be put in her body because her body is her temple. However, she testified that she in fact did put unknown substances into her body since 2019. She said in the fall of 2020, she received the pertussis vaccine into her body, which is a vaccine to protect against whooping cough. She said that she took Cervidil, which is a medication to induce labor. She took Cytoxan, which is a medicine to prevent stomach ulcers. She took Pitocin, it's a hormone used to induce labor. And then she also took Zofran, which is for nausea, which she admitted were all substances that were unknown to her. But even better, During her deposition, I asked her specifically, I said, what would you do if your doctor said you had to take an unknown substance because of your unborn child? And the appellant said that she would do it if she had informed consent, which she defined as truly knowing what the unknown substance is for and researching the data, the statistics, and the ingredients to know exactly what's being put in her body. So relying upon her testimony, Your Honors, Justices, if she had what she has defined as informed consent, she would have taken the COVID-19 vaccine. That's what takes this whole body as my temple out of religious as nature, because her belief is not religious in nature. Because if she had informed consent, she would have taken the COVID-19 vaccine, regardless that she thinks her body is her temple. And then let's look at it another way, Your Honors, is that...
Isn't that kind of just speculation? Like, is that a fact in this case?
Well, it is a fact because I asked her the question what she would do
And-
if
but-
the doctor asked her that, and she said that if she had informed consent, she would take the unknown substance. She's claiming in this case that the COVID-19 is the unknown substance. And if you go based on what she says, she controls the religious belief, because if she wants to determine what is in the product or in the medicine, she controls it. Let's say, for example, she wants to be ignorant and lazy and not decide to find out what's in the COVID-19 vaccine. Well, then it's an unknown substance. But if she takes the steps to find out what is under her definition of informed consent, then it's outside of her religious belief. That is not religious in nature. You don't get to control what is and what is not your religious belief based on informed consent. Informed consent is
Why
not in
not?
Scripture. Because if she's saying that I can't take this because my body is my temple, and I can't take an unknown substance because my body is my temple, but she also says, well, if I knew what it was, and if I did the research, then I have informed consent and I would take it. She controls whether or not she gets informed consent. She could just sit back and say, I don't want to fulfill this employment obligation of this COVID-19 vaccine, and so therefore I'm just not going to learn about it. And so now it's an unknown. This is no different than the free will exemption cases that were going around. And in those cases, Your Honor,
Hold on, isn't she, in this case with the COVID-19 vaccine, she's kind of saying, it seems like, I know what's in this. I know that based on whatever it is, wherever she gets it from, I know, let's just take the aborted human fetal tissue. I know this is in this, and because of my religious beliefs on this, I don't want to take this.
and respectfully, Your Honor, that is not an exemption request. She does not say those specific words like that. What she does at the beginning of her exemption request, she just dumps that sentence in there at the top of it. She does not tie that the aborted fetus stuff as that my body is my temple. Remember, unknown substance.
Well, I mean, but I'm looking at it, it says the well-documented process of this vaccine developed from animal and aborted human fetal tissue has compelled me to stand by my beliefs.
And refuse to take the COVID-19 vaccine. She doesn't say that that is the reason. She doesn't tie the religious nature is that is the reason that it's a body of my temple. Because she says below is it's the unknown substance that is the reason I can't take it for the body as my temple. So going to the last argument, Your Honors, with regards to sincerely held religious belief. Again, if no reasonable juror can determine that she had a sincerely held religious belief, then therefore the judge could find summary judgment. And let's look at the facts real quick. Prior to her religious exemption request in August 2021, appellant was current on all her required vaccines at Texas Children's since her employment started in 2018. She also testified that she put those unknown substances in her body since 2019. As further evidence of her insincerity of her beliefs, Your Honors, she admitted that she went online to a website and filled out a form at Calvary Chapel located in Hawaii to get her religious authority letter. She admitted that she never remotely even attended service at Calvary Chapel. She admitted she never spoke to the pastor at Calvary Chapel before getting this letter.
Are you trying to say that because her exclusion, she states all the things that she knows are in the vaccine, that those no longer matter with regard to her religion because of the one sentence that talks about unknown?
I don't think I,
Well, because Justice Hart mentioned the ingredients that she knew were in there. And I'm confused as to why we're supposed to disregard what she was aware of was in the vaccine and how that compared to religious beliefs.
well, Your Honor, what she said was, Scripture tells her you can't put an unknown substance into her body. Well, by that admission, she knows it's in the COVID-19 vaccine. And so it's not an unknown substance. And remember what I said is, she's controlling the religious belief because she said she would put an unknown vaccine if she knew what was in it, she knew the statistics, and what it was being used for. She had all that information, to be fair. But Your Honor, even if you take everything that you said that he made the prima facie case, they cannot defeat the undue hardship defense in this case. The undue hardship defense is uncontroverted, and we ask that you grant summary judgment and affirm the lower court's decision.
Thank you.
Thank you.
Mr. Woodfield?
Thank you, Justices. Let me pick up kind of towards the end of his argument, then I'll go back to the original part with respect to reasonable accommodation. You see how he laid out a substantial number of arguments with respect to what she was putting in her body, X, Y, and Z, all these things, why her sincerely held religious belief was not credible. If you look at Davis versus Fort Bend County, that is why the court emphasized that at the judicial level, you should approach it with shyness and judicial hesitancy.
Let's talk about undue hardship.
Yes.
Mr. Pat points out that no evidence was presented in opposition to the hospital's evidence.
Yeah, that's my question.
Sure. Well,
How do you, given the fact that there is no evidence in opposition, and we're talking about a summary judgment here, why hasn't the hospital established undue hardship?
Well, because Judge, we did put in evidence. We actually put an affidavit in from Mr. Stockoler, I'll be butchering his name, where there were actually 480 religious exemptions submitted and 387 were granted. So
how do we know those were not clerical physicians?
Regardless, Judge.
Who had nothing to do with patient care.
Well, that would be a fact question that they could argue in front of a jury. So here we have put in evidence, and then all the inferences are supposed to be indulged in our favor as the non-movement at the summary judgment level. So yes, they could make that argument at trial. They could say, well, we gave these 387 religious exemptions because of X, Y, and Z, but we're treating Ms. Balboa different because of all of these other reasons. And then when we go back to the case that you questioned me about earlier, you go back to the Ware case, I mean, that's exactly what we're dealing with here. We have an individual who was not given the option to actually test. She was given one option alone, and that was to take the COVID shot against her sincerely held religious beliefs or be fired. It was to either feed her family or to stick to her underlying sincerely held religious beliefs. Unlike Weiss, she was not given that same option, and in Weiss, they concluded it was an undue hardship only because both options were offered, and she had asked for religious exemptions with respect to both options, the shot and the testing. Here, you could also look back to what she was doing prior to the COVID shot being implemented. Obviously, she wasn't fired, and that was part of the record. And so I think there's clearly a fact issue for the jury to decide. What they're asking you to do, Texas Children's Hospital, to say, as a matter of law, we are going to take this from a jury of Ms. Balboa's peers and say, one, we are going to decide you did not have sincerely held religious beliefs. We're effectively going to, as a court, try your religious faith. And two, say, hey, even though you gave religious exemptions to 389 other folks, 87 folks, then we're going to decide as a matter of law she didn't fall into that category. So if you go to the McDonnell-Douglas burden shifting, which is ultimately the underlying federal analysis, once we put on that prima facie case, which I believe we had, and obviously their argument has changed somewhat over time, whereas at the trial court level, the focus was on Temple of the Lord, citing a whole host of trial court decisions from other courts that have since been overturned. And then the focus has now changed because they appreciate the fact that the cases that they had cited to the trial court in their amended motion for summary judgment are no longer good law. And in fact, the courts have ruled the exact opposite, more consistent with the Fifth Circuit, even though I don't think it's even gone as far as the Fifth Circuit's gone. Because the Fifth Circuit is saying, stay away from these things, courts. Let a jury decide. Don't come in and try someone's faith as a court. Let the folks' peers make that decision. And so I think the standard that they want you to adopt is something similar to what Passarelli and Ringhofer did at the trial court level, where you have two binary alternatives. One is safety and one is religion. Well, the Court of Appeals in Passarella rejected that. They said you can't have these, you don't necessarily have these binary alternatives when dealing with lay people when you're talking about religious beliefs and health and safety. And as the Justice pointed out, it's very clear that her concern was the aborted human fetal tissue, and she relates that to her faith. That's in line 2 of her underlying exemption. So I respectfully request that the court overturn the trial court's decision. Thank you, Your Honor.
Thank you. All right, Balboa versus Texas Children's is submitted, and we will stand in recess. Thank you. You are adjourned.